It's about 3 hours long. There'll be some, he'll go over some of the housekeeping rules, but they'll be broken up into 3 different sections for the morning. So I want to introduce Judge Ferris. He's a retired judge, spent 27 years as adjunct faculty. First off, his resume is longer than I can remember, so I'm just going to go with a couple of things here. But he's 27 years adjunct faculty with Mesa Community College and Chandler Gilbert College. 17 years as a Gilbert, presiding Gilbert Municipal Court. 17 years, but 13 with Chandler Municipal Court, correct? Justice Court, I'm sorry. If we just keep doing this every day, we'll get it better. So I apologize, but I'm gonna pass this over to the judge, and he'll take it from here.
I need to tuck this cord in. Can everybody hear okay? Okay, while I'm tucking it in, I want to introduce my co-presenters here, and you're going to hear from them. I'm going to speak to you for about 15 minutes, and then we're going to take a 10-minute break, and then we'll come back, and Kristen White, raise your hand, Kristen, she'll speak to you, and then ultimately Kimberly Anderson will be doing the last presentation. The only real rule we have is that if you have a question, we want you to just pop it out right now. Don't wait until the end. There will be time for questions because you might want to mull over it, but we would appreciate it if you would just speak up and let us know. If it's relating to what we're talking about, we don't want to move on without losing someone, okay? I'd like to briefly give you a little history of me and the fire department. It goes back 76 years. When I was 5 years old, we moved into a house over in East Phoenix, and I don't remember where it was, but it was about 2 or 3 blocks away from a firehouse. And after we were all settled in, my dad took me by the hand and we walked down to the firehouse, and the firemen were out there cleaning their apparatus and doing their thing, and we stood out on the sidewalk and we didn't interrupt him, but he says, if there ever comes a time when you can't find me, or you can't find your mother, or you can't find your older sister, you come here. They will take care of you. And I said, Dad, they don't know me. He said, it doesn't matter. They'll take care of you. And that started my whole faith and understanding about the firefighters. And as the months went on, I'd ride my bike down there and I'd wave at them and they'd wave at me. And finally my mom says, well, how about if I make up some cinnamon cookies? So she made up 2 dozen cinnamon. I knew they were cinnamon because I ate 2 of them on the way down. And she put them in a paper bag and stapled them on the handlebar so I didn't have to carry them. And I rolled down there. And sure enough, they were out there. I don't know, those trucks must get really dirty because every time I saw them, they were cleaning them. And I rolled in with these cookies and I gave them to them. And boy, I'll tell you, all of a sudden it was like I was their long lost son. And from then on, we had a really good working relationship for probably about 4 years. And when I found out we were gonna move, I went down to say goodbye. And they were just really nice about it. That was my start. Decades later, I end up over in the town of Gilbert, and a good buddy of mine is Colin DeWitt. Do any of you know Colin DeWitt? He used to be a captain over in Phoenix, and then he ultimately became the fire chief in Gilbert, and we became really close, and we were fly fish partners. And every time they would have a new academy come in, I would go in and swear them in, and I would give them the same oath that we give every other official in the state of Arizona, and it's in the statutes. And we did that for 17 years. And when I retired, they gave me this fire helmet. And it's got my name on the back. I have no idea what that cost, but it's really a neat helmet. The problem is I can't think of a lot of places where I can wear it that's appropriate. I have taken it out on the lawn to mow the lawn a couple times just to scare the neighbors, but I don't know. My wife won't let me take it to the movies. I thought we were going to go see a movie that had something to do with fires, and I was going to walk in with them. She says, no, you're leaving it in the truck. So anyway, I really have a soft spot in my heart for firemen. And having sat through thousands of trials over the 30 years that I was in court, I saw a lot of good witnesses and I saw a lot of bad ones. And unfortunately, most of the bad witnesses were either police officers or firemen. And that's when I decided right then and there, okay, I'm gonna have to find a way to solve this. And so when I retired and I wasn't under any obligation or conflict of interest, then I developed this, and I hope that you gain something from it. Yesterday, a number of people came up and said, man, I wish they'd have taught this in the academy. And so did you hear that? Maybe you need to be teaching this in the academy. I'll give you a special discount, okay? So we feel it's important, two things. Eric, stand up a minute. I'm going to use him as an example. I don't know Eric, but I know what his name is because I read it when I was short. You roll onto a scene of a fully engulfed home, and the mother comes running up and says, my daughter, she's in the front bedroom. Do you hesitate going in after her? Do you even hesitate for a minute? So you're not afraid to go in there. Okay. When you finish with that, you get back to the station and somebody walks up and gives you a subpoena and that you're going to have to testify on a trial that happened a year ago. How do you feel about that? Not so great. The irony, thank you, you can sit down. The irony is you are some of the bravest people in America, and I'm not blowing smoke. You know, you have a mystique in the American psyche. It started long before 9/11, but 9/11 really cemented it. When all of America saw the response of the New York Fire Department that went in during that catastrophe, and then later during recovery, all the volunteers that came in from all over the country. You people are heroes. And then it was cemented even further in the last couple of summers during the fires in Los Angeles. And we saw what the firefighters did there and their bravery. The reason I emphasize this is it gives you a tremendous advantage as a witness in front of a jury. Because when you walk in, you're already a hero. They love you, but you can lose it. Are there any police officers in here? We had one yesterday. No? Well, I guess I can really poke fun with them. The difference between you and a cop is the cop has a vested interest. And also, if you have 12 people sitting over in that jury, there's going to be a few of them, regardless of what happened during the voir dire proceeding where they select the jurors, there's going to be some of them who have had a bad experience, or their spouse had a bad experience, or their son or their daughter had a bad experience. And that officer then, from a credibility standpoint, has to overcome that. You don't have to do that. You don't have to do that. Your hero is walking in the door. Keep that in mind, okay, as we talk about all this. And we're going to mention it later on as we move along. One last piece of, some of you were given this little evaluation form. We would really appreciate it before you leave if you would fill it out in detail and offer any critical or complimentary comments. By the way, both these ladies are already married, so don't get excited on that end. But if you have something that you would suggest, let us know, and because we're going to really spend a lot of time with these. Okay, why? For decades, and just to give you an example, okay, I was a trial court judge for 30 years. Kim Anderson was a prosecutor for 25 years. Isn't that right? How many? Little more than that. Okay. You just kind of blot out the last ones, I imagine. And Kristen, how long were you involved in? I know she was one of my pro tems, and she was also a public defender. How many years? 20 years. 20. So do the math, and that's how long we have seen witnesses walk onto the stand. And that's a lot. And some of them were really good. Really good. Some of them, I have to tell you, Chandler had, I don't know if he's still with them or not, but no, it was Gilbert. Gilbert had a police officer who had the handwriting of a 2-year-old. And even my clerks, when they would get citations written by him, sometimes they would have to call him in and have them explain what it is he wrote on there. Well, when you have a departmental report that's handwritten, and that's going to end up in the hands of the defense counsel, boy, that gives them something to go after. You know, if you can't even write, how can you think? Well, it turns out he was a really good officer, but the handwriting really worked against him. And so we've seen some that were really good, and we've seen some that weren't. The difference is the difference between a person who walks into your fire academy for the first day and the one that's been on the department for 20 years. And it's knowledge and understanding. The reason Eric is willing to go in that building is you've been trained and you know what to expect and you're prepared for it. Isn't that right? And that goes for all of you. All of you have been trained. If you weren't trained and you weren't certified, you wouldn't be riding on that apparatus. Come on, you know that. And you know, when I first started teaching this class, we only taught it to cops. And at that time, on any particular apparatus, one firefighter was an EMT or a medic, only one. Now, how many of you now are medics or EMTs? Raise your hand. You see how this has changed? And also, and I'm not telling you anything you don't know, the fact is, what's the percentage of your calls? What house do you work in? Oh, we don't want to hear from him. What firehouse do you work in? Okay. How many calls do you average a day or on a shift? 8? How many of them are medical? There you go, okay? And that's why you're here, okay? That's why you're here. We're going to give you the knowledge. We're not going to tell you everything there is about courts, but we're going to teach you enough that you understand the system and your role in the system and how to prepare for that particular. So the knowledge and understanding that you already have as far as fire suppression and medical treatment, we're going to add this so it will make you a more complete witness when you take the stand. We're going to prepare you for court. And when you leave, and I will tell you, I'm not just blowing a whistle here, if you listen and you take notes and you pay attention, you will have the confidence that when you go to a deposition, and that's where, is anybody here from the city attorney's office? We had one here yesterday, but most of your contact with the system is going to be in depositions because we have total discovery in Arizona, which means every party knows what everybody else has. And the way they get it is they take the report and they say, okay, I want to interview that officer. And it's my understanding is this now the policy of the city attorney that we don't do just casual interviews anymore. It's going to be a deposition and the city attorney or one of their attorneys are going to be with you at that time. Okay? You need to understand going in there, hey, this is the message you want to send. And there's a fine line here. The message is, don't mess with me. You do not want to put me on the stand if I'm going to tell something that is contrary to the best interest of your client. You don't want to go there because I know what I'm doing. Now, the fine line is you don't want to sound arrogant. There's a difference between confidence and arrogance, and we don't want you to step over that. But the message is, I know what I did, and I know where I'm at, and I can explain it, and you're not going to make me look like an idiot. It's not going to happen. That's the message. And that's one reason why, and I'm sorry that they're not here, but I will tell you, probably, 95% of all the criminal cases are pled, aren't they? Okay? And I don't know about civil. What do you think the civil would be? Probably 80, 85? They all settle. Why? Because everybody knows what they have. Well, a lot of times, they have your report. Your report is generated automatically, and they get a copy of it in the discovery process, but they want to hear what you have to say. When you were tending to that person at that auto accident, what was the conversation that went on between you? Okay, they don't get that. There's no conversations in that report other than between you and the scribe. And here's the situation. They want to know what happened. And that's just part of the discovery. You show them that you know what you're doing, and all that means is you're probably never going to have to go to court. Trials are the least efficient method of disposing of cases. They're really, really expensive, and you never know what a jury's going to do. You just don't. Okay, the big difference between you and the police is that the police have a vested interest. They want to know when an officer rolls on the scene and they apprehend a criminal and they investigate a crime, they have a dog in that fight. They want to win that trial. They want that guy convicted. You don't have to worry about that. All you want to do is make sure that it's right, okay? And also, for what it's worth, you're smarter than most of the cops anyway. And I put a little footnote on here that may be just kidding, but not really. The bottom line is, if I was to go around and ask about advanced college degrees, we're going to get a higher percentage on the fire department than you're going to get in the police. You just are. Besides that, one of the reasons that you're smarter is that you are firemen and you're not police. Because very seldom, at least in Arizona, people don't shoot at firemen in Arizona. It's that simple. And so that's evidence that you are definitely smarter. Along the way, we're going to talk about some rules of evidence. We're going to also teach you some court procedure, and we're going to help prepare you for court. We will not, maybe with one exception, teach you the local department policy, okay? There is one thing that we're kind of still wrestling with as to how we're going to get past it, and we'll explain to you about that, because we have a recommendation when it comes to you being on the stand and being able to refresh your memory and what you can use and what you can't. But we're not going to waste your time. We're going to be as efficient as we can, and I'm going to finish up. You're going to take a 10-minute break, and we expect you back here at the end of 10 minutes so we can move on. 3 hours, 3 50-minute sessions, 10-minute breaks, and questions at the end of each session and at the end of the whole presentation. And please feel free to ask. You know, nobody wants to be thought an idiot. But if there's something I say that you don't understand and you leave with that misunderstanding, it could get you in trouble. And so just ask, okay? There's no dumb questions. There just isn't. And at the end. All right, these are the types of court appearances that you could be called to. In criminal, interviews and deposition. A deposition is part of the discovery process where they're going to sit down with you and they're going to record it, and they're going to have you swear you to tell the truth, and you're going to have an attorney with you, and they're going to question you. And the attorney is going to make sure they're not asking questions that are irrelevant. And at that point, that's where you are probably going to finish your participation. Very, very seldom do cases ever go to trial. They just don't. And the better you are in that deposition, the more you know that you don't have to go to trial. And when we talk about the communication model, you'll see why you don't want to, okay? You might be there for a hearing. It could be a motion to suppress or something like that, and you may have to testify in that particular hearing. Bench trials, the difference between a bench trial and a jury trial, there's two things that have to take place in any trial. You have one person who's responsible for the law, and that's the judge, under all circumstances. The big difference is who's the trier of fact. Who is it that ultimately makes the difference between what actually happened? On a bench trial, it's the judge. So the judge is also the trier of law and the trier of fact. In a jury trial, the jury is determined of the trial of fact as to what actually happened. But that's a really good protection for people who are charged with crimes. The problem with it is there's a little concept, and I'm not going to go in detail with it, but there's such a thing as jury nullification, which means the jury can do anything they want, and they've done it. You know, if you don't think so, go back and read the transcripts of the O.J. Simpson trial, because the evidence was overwhelming, and yet the jury found him not guilty, okay? And so juries, you don't know. It's always a crapshoot with the jury. In civil, you're going to have depositions again, and you might also be called for a domestic violence injunction prohibiting harassment. If, for example, you roll on the scene of a domestic violence assault and you tend to the victim, and all of a sudden, and the judge throws the guy out of the house and he wants back in, they have a hearing, you may have to come and testify as to the injuries of that particular person. And that's pretty, you're not going to have your attorney on that. In all likelihood. Small claims, generally an accident, automobile accident, and then standard civil trials. And civil trials can also go to a jury or to a bench. It depends on the counsel and what the law allows at that time. And civil, we won't worry about civil traffic hearings because you're not going to get called to them. Okay, take the notes out, and I want you to put some stars by these. These are the 10 commandments that we have for you as far as being a witness from the fire department as a EMT or a firefighter. Number one, you are never going to tell anything that you don't know is the truth. You just don't worry about it. In fact, I'm going to go cross-examine Kim over here. Kim, if I ask you a question and you don't know the answer, do you A, fill in the blanks with what you think it should be, or B, acknowledge you just don't know?
Say, I don't know.
You just don't know. That's right. That's part of being, and by the way, there's nothing wrong with saying, I don't recall, or I don't know. The difference between those two is if you say, I don't know, that means you never knew, okay? If you don't recall, that means it might be in your report, but right now you don't remember it. And we'll go into how you remedy that in a minute. But the honesty is absolutely paramount. You lose it, and it's gone forever. In my 30 years, I had 2 officers come into my court and just lie. And it was shown on the record that they lied. And each time after that case was over, I walked across the hall in one of them, and the other one I even went out and got in my building and went all the way across to the police department and went up to the chief, who was Tim, who was a friend of mine, and I said, you need to put that guy on school crossings because you don't ever want to send him into my court again because he lied in my court, which means he's never going to be able to rehabilitate himself. Once you lie in court, it's over. It's just over. You're so much better to just say, you know, it's like Abraham Lincoln had the thing about, you know, it's better, how he did it, it's better not to say anything to remove than to lie and remove all doubt. Don't tell stories. And especially, and this is something that everybody has a tendency to do. You people have standard practices, isn't that right? That when you roll on the scene and you detect certain that's going on with that patient, you have certain practices that you're going to do. And you do it every time. You know, if you know someone has an obstructed airway, is there a standard practice for that? Yeah, there is. So if a year after this event, and you've gone on 1,440 calls in the meantime, and you don't recall you don't have a fresh, independent recollection of what happened on that particular call, then just say, I don't recall. Don't say, or in your own mind say, well, you know, normally this is what I always do, so I must have done it then. So yeah, that's what I did. The minute you do that, you open yourself. You open yourself because the opposing party will always have an opportunity to question you further, and they already have a copy of your report. They know what the answer is. And so it's entirely possible, one thing that you might want to recall at all times is that before you go into any of these events, you are going to really, really, really review that report and go over it in detail, just very detailed, and commit it to memory. Because it's a lot better to say, this is what I did, this is what I did, this is what I did, this was the response, this is what I did, rather than say, gee, I'm sorry, I don't remember. But it's in the report. If it's in the report, you have access to it. Okay? There are no reports dealing with the fire department that you can't see ahead of time. That's not cheating, that's just smart. Okay? Your integrity as a firefighter, don't blow the image that all firefighters in this room have just because you do something stupid in a deposition. You need to understand your role. This is one thing cops have a harder time with because they have a dog in the fight. You know, sometimes they'll start arguing with attorneys. Well, that's not their job. It's not yours either. You just understand you have a role. My role is to come in and tell the truth about what happened on that particular day at that particular event. You need to understand the importance of visual impression, and that's not just a graphic or something. It's your whole countenance. One of the things that you understand, and I think, Kim, you talk about exclusion of witnesses, don't you? Yeah. When you're called to be a witness, the judge is going to swear a whole bunch of witnesses and send them out. You're not going to be allowed to see everybody else's testimony or hear everybody else's testimony. But when they call you in, the jury is watching you from the time you set foot in the door until the time you leave. And how you present yourself, I would suggest always wear a uniform to go to court. Reinforce visually that, hey, I'm a fireman. I'm one of the heroes. I'm one of the guys you really love. I'm one of the gals that you saw do this. And reinforce that visually. I will tell you from personal experience, juries are more impressed by what they see than what they hear. They just do. It's part of the communication process. And so realize that you're always under scrutiny. Not just sitting up straight and answering questions directly to the jury, which we advocate, but your dress, your language, everything, that whole image really conveys a great deal to the jury. Understand what law applies to you. If there are going to be some things that you just don't worry about it. You just don't. But the rules of evidence do. And the rules of evidence in Arizona are only 70 pages. That's it, 70 pages. You can read them. You know, they're published. You can get them online. Arizona Rules of Evidence on the Supreme Court website. Not bad reading. It might be a little boring about some of the stuff, but you can skim through the stuff you don't think is going to be relevant. But I would suggest you might want to take a look at the rules. And they're, like I say, you know, it's not rocket science. It's just not. Master your legal skill, your language skills. When somebody asks you a question, turn to the jury and respond in the best English you can muster. Okay? Try not to use contractions. Try not to go, well, yeah, it should be struck completely out of your vocabulary, because all that does is make them think, how smart is this person? You know, you probably know people that when you speak to them for the first time, you know how smart they are. It doesn't take, you know, Einstein to figure that out. Well, juries are doing the same thing. And that conclusion is what they multiply what you tell them. And that's the significance of your testimony. Body language speaks louder than words. Don't slouch up on the stand. Stand up straight, walk straight. You know, look as the professional that you are. And here's the deal. None of those people know anything about this case. They've been sorted out to make sure they don't know anything about this case. And so you have to paint that picture for them. And the more vivid you can paint that picture, the greater they'll understand what actually happened. Well, those are your 10 commandments, along with, oh, gee, let's not get angry. You know, this is one of my favorite ones. If you simmer, you burn. It's that simple. I can remember in our court, we had a prosecutor. Her name was Jennifer Green, and she's now a Superior Court judge. In fact, she's a presiding criminal judge, and she is just a pistol. I really loved having her come into my court. And we had a public defender who was a gal who she just didn't like Jennifer, and Jennifer didn't like her. And whenever they would come into court for trial, Jennifer's #1 goal was to piss her off. And she did. She just went bent over backwards to cause trouble for her. And I'd have to call him up to the bench and turn off the record, and I said, Jennifer, quit it. Just leave her alone. Deal with the facts. And she'll, what? What am I? Well, she'd give me this innocent crap like she had wings, you know, and I'm going, just put the horns away and let's go do this, okay? But if you're on the stand and you get angry, I will tell you right now, the jury is not going to like that. Now, they may not like the attorney that made you angry, but the real impact is going to be on the significance they give your testimony. If you do not prepare, you know, if you don't review the report before you go anywhere and really study it, not just read it, but study it, then you're just asking for an embarrassment when you take the stand. If you don't take anything away from this seminar, prepare, prepare, prepare. On the stand is not the time to prepare. It's before you go. I mean, how much sense would it make if you rolled onto a house fire and all 4 people on your unit, on your apparatus, say, oh, gee, what should we do? Hey, chief, you want to tell me how to do this? Doesn't make a lot of sense. And it doesn't make any sense in court either. It really doesn't. Okay. The nature of evidence. We're going to talk about the purpose, content versus weight, credibility, relevance, documents, diagrams, and photos. The purpose of evidence is to bring the facts into the attention of the trier of fact, whether it's a judge or whether it's the jury. Okay? They don't know anything. And there's rules that say you can't enter this, and There's rules that say you can't. I'll give you an example. With some exceptions and under certain conditions, police reports are not admissible. They're not admissible because they have conclusions. And if you want the conclusion that's on there, you bring the person in who wrote the document and you cross-examine him and you let him give you the conclusion. Okay? Now, most of your reports don't have conclusions. What they have is facts. They did this, they did that, we did this, we observed this. And so, in some cases, that document may well be admitted. We mentioned that. This is really imperative. It's very easy for you to say, look, I was there. They weren't. Never lose sight of the fact that you are their only window into what happened at that time. Now, there may be other people that were there and they may be called as well, but your perception has to be, I am the only person. And so I really have to get it right. Before I go any further, I want to talk to you about memory real quick. You may not be able to read all this, but I'm going to tell you what it says. And if you have a complaint with it, you let me know. Let's say you get called on some sort of an event, and the event calls for your medical expertise, and you perform what you're supposed to do. Now, I'm taking these numbers off what I heard from some officers yesterday. So if it turns out that you disagree, then take it up with the idiots that were here yesterday, okay? All right. Station that he told me, he said they average between 6 and 8 calls a shift. Would you all agree that that might be close? Okay, let's make it conservative, and we'll just say 6. Okay, 6 calls on a shift. In 90 days, in 3 months, they may work 60 days. Okay? So we take the 60 times 6, and we get 360 events over a 90-day period. 90-day period is 1/4 of a year. We multiply that times 4, and you have 1,440 events. A year after today, you get a subpoena for what happened here. Okay? Is there anybody here who has a photographic memory that without reviewing anything, and assuming it was just a vanilla run, it was like every other run you've done, that 1,440 runs later, a year, that you can remember everything that you did? Is there honestly anybody that can do that? Because I want to shake your hand. I don't think there is. And that's why you review your report. And that's why you try to refresh your memory before you take the stand. And Kim, are you the one that talks about refreshing memory? Okay. She's going to go on to that in the 3rd hour, so I won't waste a whole lot more time. Understand that content versus weight. Weight is how significant or how much weight that person gives your testimony. Example, you might have, say, a criminal case where a guy gets apprehended and you have a nun. My favorite witnesses are nuns. The nun takes the stand and she identifies him coming out of the bank. And her testimony says, that's the man I saw walk out with the gun and the bag of money. And then during the defense, the defendant's mother takes the stand and says, oh no, Harold was home with me and we were watching Jeopardy at that time. Now, which one of those are you going to give the most weight to? Probably the nun. Okay, probably the nun. And is it just because she's a nun? No, it's because she has no axe to grind. Okay, you know, Harold's mother doesn't want him going to prison. And so you're probably not going to give a lot of weight to that particular testimony. And that weight, you take the content and you multiply it times the weight that you give it, and you end up with the credibility. And you take the content, your credibility, and the weight. When you leave the stand, you want to know that the jury believed everything you said. That's your goal. That's when you win. Cops win when the guy gets convicted. You win when you leave the court knowing that I told the absolute truth and I painted the picture to the best of my ability. And then you've won. And that's, you don't have a dog any further in that fight. You walk in with it. Like I mentioned before, you are national heroes, even though they've never met you. If you walk in and you have the uniform of a Mesa EMT or medical, and in fact, it used to be Mesa Fire was on the back of your shirt. What does it say now on the back of your shirt? Mesa what? Fire and medical. That's right. And we know out of 8 runs, probably 8 of them are going to be medical. And one of the reasons, it's a little different than, Chicago or the Bronx, where they're really, really old buildings and maybe the code wasn't what it should be now. Most of Arizona is relatively new, and we just don't have the percentage of fires that they have. So you walk in and you've got that uniform on, you have the credibility walking in the door. You need to use it. You can lose it. You can lose it. Relevance is really kind of fun. That's evidence which tends to prove a material fact. If, for example, it becomes important that this particular victim that you're tending to had some serious physical injuries. Maybe there was a fight between neighbors, and the one neighbor pulled out a knife and cut up the person, and you were the one who attended them, and when you were the first medical person on the scene, they were really a mess, and you cleaned them up, and you did this, and you did that, and that becomes really, really relevant, what you did. Now, the fact that his wife was a real fox, that's not relevant, okay? The fact that they had a Labrador Retriever, well, I love them dearly, that's not relevant. Unless the dog got in your way, that might be an issue, I don't know. But it has to be a material fact. Your evidence is going to clarify that and support that. Then it becomes relevant. All evidence has to be relevant. Interesting isn't enough. The fact that the wife was a fox, well, I'm sure that the male members of the jury would find that most interesting, but in fact, the judge isn't going to let it in. It's that simple. Documents are really fun. 5 minutes, okay. Boy, 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 boy. You're going to have to do the communication model then, okay? Because I want to finish up with the documents. With the document, it's the content that's important. The exception to that is that the only way that the existence of the document would be an issue if there was some question as to whether or not the document even existed. For example, if you ran on the report and you did your thing and afterwards you had a little notepad and you kept your own notes, that's really kind of dangerous, to be honest with you. It's a good idea if you type them up and add them to the report. Okay, but if you do that and they find out you did that, but you did not tell them that you did that, the fact that you didn't do it makes that the existence of that document a relative issue, a relevant issue. But generally, it's the content. In order to get a document in, you have to lay foundation. The foundation means somebody, and it's generally the foundation is always going to be the author for you. It's going to be the author, and that author is when you, as I understand it, you roll on the scene of a medical, you've got 3 people attending and you have the scribe, right? Isn't that the way it is? So the scribe is sitting there and he's got, don't they do it like on an iPad now? Okay, on the iPad, and maybe you're putting an IV in. Maybe you're dealing with the respiratory. You're telling him what you're doing. Isn't that right? And he records you and what you did. Okay, then the scribe can be called to testify what he was told, but he can't testify, and he can testify what he watched you do, but he can't testify to any conversations that you had with them. You have to be called to do that. Okay, and the conversation just might have a lot to do with it. Maybe you're attending to a stabbing wound, and if you're attending to a stabbing wound, isn't it important for you to know how big the knife was? I would think that if on a wound like that, you'd want to know how deep it is, and so you ask, the victim, what did he stab you with? He stabbed me with a big old butcher knife. Okay, and then what happens? He dies. Okay? He has to know he was going to die in order to get that statement in, though, for what it's worth. Dying declaration. The document can be used to refresh your memory if you are the author. if you are the author, and we're going to deal with that in detail. Your report is your record, it's your memory, and it's your validation of what's on there. But if it's your document, only. I'm going to stop right now, and we'll just go to some questions, and I'm going to let you do the communication model, okay? You have any questions about anything I've said so far? You people are either really brilliant or sleeping. I'm not sure which it is. Okay, we're going to take 10 minutes. We want you back in here at 9 o'clock sharp. Okay? 9 o'clock. This was something I didn't have a chance to get to, but since we've got a few minutes, I want to go into it because it's really vital that you understand this. Years ago, the Bell Labs came up with this diagram which explains any two entities communicating with each other. And I want to walk through it and make sure that you understand it because it's vital for you to communicate with that jury, and you need to understand how this model works so that it can be effective. First of all, the thing that's most important is that you understand that every person has an inventory, and that inventory includes attitudes, interests, knowledge, and skills. And that's whether you speak Spanish, what your training is. Maybe you like to do off-road riding. You could probably sit down with 4 sheets of paper and just fill them out and say, wow, that's me. And the thing that's important about that is that these form your values. Your values are what are important to you. Is your integrity important to you? Is your honesty important? Is your job and the service that you perform important? You have those attitudes, interests, knowledge, and skills. Where this becomes interesting, though, is when you're in a jury, you have 12 people, or 6 people, or 8 people, and they all have a different inventory than you do. And they may not understand. For example, if you stand up there and tell them that you exited your what do you call them again? Not a truck. Your apparatus. But if you stand up there and you say, hey, yeah, I exited my apparatus, jury's not going to know what that means. They're just not. And so you need to always take into account what these people's attitudes, interests, knowledge, and skills might be. Understand that the chances are 99.9% they have a very positive attitude of you as a firefighter. And so you have that going for you. That's a helpful thing. Police don't have that, but you do, and you can take advantage of it. Here's how the thing works. Everything that you see, everything you perceive is filtered through this. I'll give you an example. All the things that you perceive, you do it through your eyes, ears, nose, mouth, and touch. Now, I'm going to guess that everybody in here is wearing a belt. But how many of you were thinking about feeling that belt until I said something about it? No, you filter it out. You don't pay attention to it. Although it's data that your body is inputting, maybe you have shoes that are uncomfortable. That's data that you are perceiving, okay? Everything that we perceive is filtered by this. And as a result of that, for example, you might, I'm going to go out on a limb here. Maybe you have a real positive attitude toward a particular race of people. And it's a very positive attitude. Whatever your interactions are with that, they're always going to be positive. But your interaction with another race might be totally different, even though the experience may be exactly the same. Because of your attitude, it changes what your perception is. It also is going to change how you transmit any information. Let's go back to a truck, okay? They don't know what an apparatus is, but they know what a truck is. So you take that into account, and you are going to encode, and we all encode, and the code we use, by the way, is English in the court, okay? You have your own little medical code, terms that you use. For example, are you a medic? Okay, what's your term for a heart attack? What is it? Okay, Does anybody use cardiac infarction? Is that what it's called? Was that a heart attack? Most people don't know that. They don't. And so you want to make sure that whatever you're encoding, it's going to be in something that they will understand. Okay? Now, you also have the message, and that's your testimony. But it's going to be filtered going out, and it's going to be filtered going back. And also, it's going to be filtered in feedback. Feedback's really important to you as a witness. And I have watched hundreds of times in jury trials, excuse me, where a witness is on the stand, and they're talking specifically right to the attorney that's questioning them, because the attorney is standing right in front of them, and they're carrying on this conversation, totally ignoring the jury. And all of a sudden, I look over, and one of the juries is doodling. They're not paying any attention. Okay, well, that's a feedback that you miss. If you turn around and every time you are asked a question by an attorney, and you respond and you paint the picture to the jury, look them in the eye, look from eye to eye, make the eye-to-eye contact with them. Don't let them doodle on you, okay? And even, I'm sure, there are probably some of you in here today that are bored stiff for some reason or another. Probably because you're mentally short, I don't know. But bottom line is, if you look at people in the eye while you are testifying, you will keep their attention. A jury member, I'll use Chief John there for example, if I'm sitting there looking at you and I'm looking you right in the eye and I'm talking to you, you cannot look away from me. Jurors can't do it. And so use that to command their attention. Keep them, and the only way you can do that is look for the feedback. You know, what are they doing? It's a good thing they don't let them take phones into jury boxes, because I'm sure half of them would be sitting there doing something on a phone. It's just the way it works. Ultimately, this goes back and forth. You're sending the prosecutor or the opposing attorney gives you a question, they send you the message, you know what their knowledge, attitudes, interests, or at least their knowledge is. It's basically a legal knowledge for the most part. And what their attitude toward you is, if you're a witness for the opposition, then they probably have it might be a bad attitude, but it's probably respectful. It's probably respectful. Remember, when you walk in, you're a hero. You know, that sounds trite, but it's true. Believe me, it's true. And so even though an attorney may be cross-examining you, there's a certain degree of respect that you have coming in the door that just a general lay witness doesn't have. They have to earn it by their testimony. You have it walking in the door. And that attitude is a real secret. It's a real secret to your success as a witness. And it's vital that when you prepare, when you read your report, you come in and you want to carry that. Remember, the message you're sending them subliminally is, you don't want to mess with me. You're not rude about it. You know, you're not in their face, but you're giving them the responses which establish you as an expert, and you are. You know, when it comes to testimony, Joe Smith off the street, he can't testify as to conclusions, okay? He can only testify to what he sees, what he heard, maybe what he smelled, what he tasted. That's it. But you are experts, and the attorney is probably going to qualify you as an expert. And they're going to ask you, what was your training? Were you ever certified with that training? Yes. And then they're going to turn to the judge and say, Judge, I would like this witness to be considered an expert, and we can have them draw conclusions. Now all of a sudden you're an expert. You just got elevated, okay, especially in the eyes of the jury. Because not only are you a good guy, a brave person because of what you do, you're also really good at what you do. You're an expert, and that gives weight to your testimony. Do you have any questions about that? I can't emphasize the importance that you take this diagram that's in your notes and draw up an inventory of your own attitudes, interests, and knowledge and skills, and ask yourself whether or not that influences you as to how you relate to people, because it does. There was a Medicare that was here yesterday that on the back of his shirt it said something about Montana. Well, I'm going to go fish Montana next week. You know, I sought him out. You know, I have a positive attitude about Montana. I love it. That's a great state. They're having some problems up there politically, but nowhere near what Portland has, you know. And they aren't trying to defund the fire department or the police department. Good for them. But it's a question of we identify with that. Somebody might walk in with a big old cowboy hat on, okay? Some of you will look at that and say, what a dork, you know. What kind of boots you wearing, dude? You know, because of an attitude. On the other hand, if you look down and you're wearing a pair of Tony Lamas, that's probably a little different in the way you react to them. And not that you, and I'm not telling you need to pander to the jury, but you need to be aware they are different from you. And that difference is something you have to overcome in your testimony. Anything you want to add to that? No? Okay, we're going to take a break.
Welcome back. Sorry for all the loud and yelling, trying to get these mics to work. Welcome back to part two. I'm going to introduce Kristen White. I think you said 29 years, not just defense and prosecution. So I'll let you, Kristen, take it.
Good morning, welcome. Thank you for coming. My name is Kristen Gentili White. I am a private attorney. I have been an attorney for 29 years. I've been in all the different roles in the justice system. I've been a prosecutor. I first started in Mesa, so Mesa always has a special place in my heart. I was a city prosecutor in Mesa for several years. I was also a Maricopa County attorney. I had defense contracts, so I did defense. I've been a pro tem in Gilbert for over 20 years. But my main job is I am a tax and estate planning attorney. So I argue with the government, and boy, that's a ton of fun. But everything that you do in your realm, in your job, I can apply it to mine, and I can apply mine to yours, because really what you're looking at is the end. So you're always preparing from the beginning for the end. Keep that in mind. My presentation today is going to deal with the middle part, okay? So Judge Ferris talked a lot about what you do to prepare and just kind of a general overview. And my part is from the time you get to the station, you go out on a call until the time that you actually get that subpoena, and then we'll turn that over to Kimberly, and then she's going to explain to you what happens in court. So a couple fun facts about me. I have 5 productive adult children and I've been married for a long time. And the funnest thing that just happened to me lately is I became an Italian citizen. So very Italian, you'll hear a lot of Italian stuff. So let's start with, we just reviewed, this is what Judge Ferris mostly spoke about. And again, if you have any questions, just raise your hand and we'll do our best to answer them. So we're going to identify the players in this system. So remember, my presentation is starting with you go out on a call, and what happens from going out on the call until you get that subpoena. You really have to know who you're dealing with, and you have to be able to read the room. You've heard a lot about that lately. You have to be able to read the room to know what you have to do with your reports. And your reports are probably the most important thing. The writing, the grammar, all of that. A lot of times you'll hear their first impression of you is when you walk into the courtroom. I'm going to take that back a little bit, and the first impression of you is that report that you get. So a lot is being judged on you by your writing style, what you have in there, what you don't have in there, how you speak, your grammar, your punctuation, and your writing, like Judge Ferris said. Most of it's going to be on computers now and digital, so you may not see a lot of that, but there still may be some of that out there. Okay, so the players in this system. You have the defendant, defense counsel, the prosecutor, the witnesses, other witnesses, triers of fact. You're also going to have people like the interpreter. So if you ever have an interpreter case where they're interpreting, you have to make sure that you're not speaking really fast. Like I talk really fast, and so I have to slow myself down and judge how quickly the interpreter is able to say what I am talking about. The prosecutor. So the prosecutor, they're attorneys, and the prosecutors have a higher burden or a higher ethical standard than attorneys. So we all have our ethical standards, but prosecutors have a higher ethical standard because their job is to do justice. So your prosecutors are really a good resource for you. They're going to help you. They've been through it before. Also, just a little injection. If you ever do get a subpoena, and how many of you have testified before and been in the courtroom? Okay, for those of you who have not raised your hand, I encourage you after this and sometime in the near future, go to court. Talk to the prosecutor, say what's a good case, what's a good jury trial case, you know, and get some facts about it. Now, they usually don't go, but it would be really helpful for you to sit in on a court case, on an evidentiary hearing, and you're always welcome to do that because the courts are open. All right, so triers of fact, you either have a judge or a jury, okay? And it depends on the type of charge and the type of case, whether it's misdemeanor or felony, whether you're actually going to get a judge or a jury. The gallery, the press. My son plays hockey, and so I read this book one time. They talked about sports being the microcosm of life. And so every player, you know, in the hockey arena, they play different roles. And same with you. You have your department, and then you have the court. So everybody plays a role, and you just need to make sure you know who they are. All right, defendant. What's his goal? Avoid responsibility, or I say defend himself or herself. Defense counsel, I believe defense counsel are the smartest people in the room. Kimberly's going to disagree, but I believe the defense counsel are the smartest people in the room because if you get a really good defense attorney, they teach the prosecutors more about their case. So if you do go visit a courtroom, make sure it's a good defense attorney. Plaintiff's counsel, that could be a prosecutor in civil cases. That would be the plaintiff's counsel. The judge, everybody loves the judge. The juries love the judge. So always be respectful to the judge. But the judge's job is to protect the record, to make sure that objections are ruled on, to make sure that the record is kept, that the interpreter is working correctly. So really the judge, they take care of everything in the courtroom. So always be respectful to the judge. I'm going to add another one there, the clerk in the courtroom. Always be nice to the clerk because the clerks actually run the courtroom. The jury, I have been on a jury even in my own courtroom, and the juries, as they're picked, boy, they change when they get into that jury box. They all of a sudden have this new sense of authority and smarts and everything. So they change once they get into that jury box. And one thing about, we had a question yesterday, your social media and talking about your phones in the courtroom. When I was on a jury, the judge, he was constantly on his computer doing stuff. Well, I knew what he was doing, but the jury asked me, because they knew that I worked there, they said, what's he doing? And I said, oh, he must be, taking notes about the case. He wasn't, but they watched what he was doing and were very interested in that. So if you have your phones in the courtroom or you have your phones in an interview or deposition, put them away because they're looking at everything you do. And if you are not interested in the case, they're not going to be interested either. All right, and your job, the EMTs or the paramedics, you're different than the police officers. The police officers are coming to conclusions in their reports. You're just reporting the facts, so just the facts or just the facts. And in your report, when you leave the station, you need to be very aware of that. All right, influencing the trier of fact. Remember, the trier of fact could be the judge or the jury. So preparation. If you fail to prepare, you prepare to fail. So in your reports, and maybe, I don't know if you have like writing classes or whatever, but the writing is very important. So in my job, I fight with the IRS all the time. And you never underestimate the power of a lazy person or the power you have over a lazy person. And many of you are a little afraid of the IRS. I have a lot of fun with them. So I can turn a stack of receipts this big into 3 huge folders. They come to my office, they get that, and they go, A week later, I get, everything looks perfect. And I know darn well it is not perfect. But your reports, if your reports are good, you are probably not going to show up in court. You're probably not going to show up in court. And again, handwriting, composition, accuracy, spelling. Do not make spelling errors. Do not use contractions. Don't as opposed to do not. Pronouns. he, she, say the person's name, because you're not going to remember your, 14, 40 different calls that you go on. You're not going to remember that. There's also something called passive voice that in law school, it's just drilled out of us. So it's very difficult for an attorney to read something that's passive because you're not actually saying who did what. If you came to this presentation today, as opposed to the presentation happened today. Well, and I was there. So you came to the presentation. You're being very direct in what you're saying. So in your reports, make sure you're actually identifying the correct noun and the correct verb in your report. Again, you're being judged on that report. That's the first time they're seeing you, not as you're coming into the courtroom. So they're judging their case, prosecutors and defense attorneys, based on that report. All right, any questions so far? Okay. All right, the visual impressions. So if you're writing your report, you may go Val Vista and Baseline 3 times a day, every day of the week, every day that you're working during the year. You may know that intersection like the back of your hand. But if you're testifying or you're doing an interview for, say, a case in Maricopa County, and somebody on the jury is from Buckeye, they don't know Val Vista and Baseline at all. So they have no idea what it is. So when you write your report, keep in mind 2 things. First of all, you don't know who you're presenting this to, or the jury, okay? And 2, you got 1,440 cases. You need something to remember that by, okay? So if you're always on Val Vista and Baseline, what is it about this particular call that's going to distinguish that? So here's an example. In your report, you say, we got a call, we went to Val Vista and Baseline. It was about 5 in the afternoon. Okay, great. How can we make that better? You say, got on the call, it was Val Vista and Baseline. It's a 16 different lanes between that 4-way intersection. There's commercial areas on all different corners. It was about 5 o'clock in the afternoon, late July on a holiday weekend. The sun was still out. They were doing some construction on the Circle K, so there was construction vehicles in that parking lot. When you write that, you're going to remember, okay? The defense attorney or the prosecutor is going to go, they must know what's going on here. They're going to remember this, so maybe I'm not going to challenge that as much. But it's giving you a great visual recollection of what you're doing, because when you do get into the interviews or you do get into the depositions, and they ask you about that, and you refresh your recollection by looking at your report, you're going to go, I remember that. It was really hot that day, and those construction vehicles were making a ton of noise. So then everything else will come back to you. And the other thing too, if you're on a jury, if you have a jury trial, and again, you're in Maricopa County, this happened in Gilbert, and everybody's from Buckeye that's on the jury, they don't know this area. So you really have to give them the visual to put them in there. So the description I just gave of Vista and Baseline's hot, the construction vehicles at the Circle K, I'm putting myself in there, and then you start talking, and I can see you doing what you're doing, with the patients or with the car accident. I can put myself there, as opposed to just Val Vista and Baseline, which I may not even know what the intersection is. All right, some simple rules of procedure. Discovery in Arizona, they get to see everything. We had some discussions yesterday about taking some personal notes and then using that to refresh your recollection. If you take notes and you're using that, you have to turn it over to the prosecutor. If you forget, you better be talking to the prosecutor way before this trial or this interview. Just let them know what you have. They will handle that for you. But you don't want to go into court and the defense attorney ask you, because they will, did you make any other notes of this event? And you go, well, yeah, I keep a diary of this. The court's going to go into recess. Everybody's going to start fighting. The jury's going to go out. Everybody's going to start fighting, and you're going to be the villain. So don't do that. If you have any notes, either destroy them right after you do your report, or make sure the prosecutor knows about that. Also, about your credibility, when you do your reports and when you are actually in the interviews or the depositions, these attorneys know everything about you, everything about you. If you have Facebook pages where you have maybe not so appropriate things for your professionalism, They're going to find it. There are listservs with defense attorneys. They talk about you. They talk about all the witnesses. They talk about the police. So they are very aware of you, and you may not be aware of them. All right, so the procedure. The defendants have a right to confront, okay? So how this goes, if you're in your interview, now you've already written your fantastic report, everything's great, you have your good grammar, you have your descriptions in there, you've turned it over, you've done everything, and now the defense attorney reads it and go, yeah, I still want to interview them. Okay, so they bring you in for an interview. Interview deposition, usually depositions are a little more formal and they're transcribed, but whatever you say in that interview, they're comparing it to your police report and they're going to try to impeach you there. And then you go to trial. Now they have two things to try to catch you up on. So a couple important things about that. Don't ever speculate. Don't get down a rabbit hole with them. If you don't know the answer, say, I either don't know or I can't recall. Can I use my report to refresh? You're not going to be able to go in these interviews with your report and go, okay, so on this date, this is what happened, blah, 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 blah. Your report's going to go away and they're going to ask you questions. And if you say, I can't recall, but I think it might be in my police report. Okay, then you can refer to your report. You done? Yes, I'm done. Okay, what was the license plate? XYZ123. And it was a white car. And then you go back to having the interview with the defense attorney. Expert witnesses. Many of you will be qualified. Expert, you're all experts, but they have to do a process to qualify you as an expert. So they'll ask you about your training. One thing that I highly encourage you to do is to keep a resume or a CV of all the trainings you've been to, of all of the different certifications you have, of all the departments you've worked for. If you had any special things, just keep a running list of that. And every time you do something like this class, put it on there, because that will become very important to qualify you as an expert and to let the defense attorney know, I really know what I'm doing and I have a bunch of training, okay? All right, so to refresh your memory, you can review your report. Again, we're still talking about the interviews and the depositions. We haven't got to the trial yet. You can review your report, but you can't read from it. And so if you have to review it, completely normal, everyone does it. Don't feel bad about doing it because you want to be factually correct. The minute you say something that's even slightly different than what's in that report during the interview, they gotcha. So take your time, listen to their questions, answer their questions. Don't give them any more information than they need, because then they get you tripped up. And that's exactly what they're supposed to do, okay? So when do you prepare? In my segment, you prepare the minute you leave the fire station and you're going on a call, okay? That's when you start preparing, in my mind. Then it becomes your report, then it becomes the interview or the deposition, and then eventually it's gonna get to the trial. All right, the depositions and the interviews, they are really important because usually the trials are shut down right after that. If they know that you have a good CV with all of your training, if they know your report is well written, that you come to the interviews in your uniform, because again, that makes a statement to them, okay? You have worked really hard to be in this position and you deserve to wear that uniform into an interview, okay? So wear it. And they judge your ability to speak. They judge your ability to look at, read your report, to recall the facts. And usually if you're good at that, they're not going to trial. They're not going to trial unless they got nothing to lose. All right. We talked a little bit about the difference between the deposition and interviews. Many times now they're always being transcribed. They may have somebody transcribing it in there, or they may just have the tapes, okay? They may just be recording with tapes. I would encourage you that if it does go to trial and you have done an interview, and whether it's been transcribed or there's a tape, go talk to the prosecutor, not the day of, okay? A couple days before, say, can I listen to that interview tape again? Were these transcribed? Can I take a look at that? You're allowed to do that. And you get on the stand, the defense attorney says, did you review your report prior to taking the stand? Yeah, I did. Did you review the tapes? Yes, I did. Did you speak to the prosecutor about the case? Yes, I did. But you don't want to start speaking to other witnesses about the case because they'll ask you that. Did you speak to anybody else about the case? Well, yeah, I was just talking to somebody out in the hallway about it. You can't do that. okay? So make sure you talk to the prosecutor, again, about who you can and cannot talk to about the case. All right, so we just touched on this a little. Make sure to review all your reports, and reviewing your reports does not mean the day of you go get it. It means a couple days before. As soon as you know that there's going to be an interview, you get that report, you review it, you make sure the supplements are attached, if there's supplements, or however Mesa keeps track of their reports. Make sure everything's attached, make sure you've listened to everything. If you need to talk to the prosecutor about the case, talk to the prosecutor about what's the issue here, why are we even doing this? They'll give you all the information. If there are any pictures or anything else that you included with your report, make sure you have those. The defense attorney will have them, I guarantee it. They will have all of that. They will have, the video recordings of everything. And defense attorneys never ask a question they don't already know the answer to, if they're a good defense attorney. Now, there's some that are terrible, but most good defense attorneys, they're not going to ask you a question that they don't already know the answer. So keep that in mind as they're asking you questions. Sorry. We had prepare answers to discrepancies. Okay, so be familiar with the discrepancies. Now, it can happen where you say the car was white when it was actually pink, and you just missed it. Okay, if that happens, just be honest about it, because they know the car was pink, you thought it was white. Why did you say the car was pink? Well, the sun was in my eyes. And there was a pink car over there, but the sun was in my eyes, but I'm certainly sure that this was the car that I was talking about. And you can explain it like that, because there are going to be discrepancies. You are never going to be 100%, but it's okay to admit if you were wrong or you didn't put that in your report. Yesterday, we had a question where they talked about the breathing, and the firefighter said, if I had it in the report that, there was an issue with breathing, but like on a scale of 1 to 10, they didn't document that in their report. But you remember they were really having a lot of trouble, all right? And if the defense attorney asks you, you say, what was the problem with the breathing? And you said, well, they were really, and on a scale of 1 to 10, they were at like a 9. They were having a lot of trouble. And the defense attorney says, well, that, you didn't put that in your report. Do you have an independent recollection of that? Yes, I do. How come you didn't put it in your report? I just didn't put it in my report, but I do have the independent recollection. And that's okay. Just admit that. You don't have to come up with anything that's, very too detailed about it. Just, I didn't put that in my report, but I do have an independent recollection. Kimberly, would that work for you? Yeah. Okay, so know what the discrepancies are and be prepared. Think about those before. So if you know there's a discrepancy, think about it before you get there and before you're put on, on the stand and trying to explain it. For your deposition interviews, again, make sure you're on time. Like I said, make sure you're in your uniform. You've earned it. Wear it. Make sure you have your report. Don't be all flustered and everything. Just walk in calmly and speak nice to the, answer their questions. One thing to be careful of, defense attorneys, when they're too nice, they're really, really mean. Okay, so there's a great defense attorney. He looks like he could be your grandpa. He has tons of kids, tons of grandkids who always start talking about that to you, and he'll get you to like him. It's almost like you're talking to your grandpa, and he's got you. He's got you. So just be careful of them. The jerks, yeah, you know what they are. But the really nice ones, they are really nice for a reason, because they are soliciting information from you, and they will crucify you at trial. Plan to be a good listener. As a defense attorney, when I would go see Kimberly, I would let her talk. And I would have in mind, okay, what's going to be success for this case? Talk to the client about it. What's going to be good? I would go in and I'm thinking, okay, we're not settling for anything less. I'd go in and talk to her, and I'm like, we will take it. Yep, where do we sign? Can we sign this today? So just let them talk. Let them ask the question. If you don't understand their questions, ask them to repeat it. If they ask you a question and you're not sure how to answer it, what you do is you have your water with you and you go, can you repeat that question? And they repeat it, and then by that time you should have the answer, okay? don't answer a question that you don't understand the question, okay? And they're confusing you on purpose. So if you don't understand the question, say, can you clarify that? You know, it didn't happen on that day. It was actually the day before. So why are you asking me about that next day? Okay. Don't get ahead of yourself. Again, this is don't answer a question you have not been asked. Don't elaborate on questions that you have not been asked, because they'll let you talk. In an interview, they are going to let you just talk till the cows come home. Okay. In the courtroom, they're not going to let you talk. On cross-examination with the defense attorney, it is yes or no. And they're going to try to cut you off, and you're going to try to elaborate, and maybe you can't answer yes or no, okay? And your prosecutor should be listening and taking notes, and then they're going to give you a chance to elaborate when they do redirect. But only answer the questions that are asked. All right, so for the deposition and interviews, the hurdles to overcome, your temper, they really want to get at you. They really want to make you angry, because when you're angry, you say stuff that's maybe not true, and you start elaborating on things. So they really want to get you to do that. Just remain calm, because you have to be calm when you go out on your calls. You can't be all frantic and panicked if somebody right there is dying and you have to help them. You have to be calm and collected. Same thing has to happen during your interviews. Your integrity is definitely going to be challenged. It doesn't mean anything. The defense attorneys are not doing this because they think you're a bad person. They're doing this because that's their job. Okay, that's their job. But once you lie in an interview or stretch the truth or are not truthful, now you have a reputation, and you will never succeed in the justice system, because, like I told you, they all know who you are before they even meet you. Oh, your intelligence will be questioned. Here's what defense attorneys like to do with the police officers. They'll get them on the stand. Now remember, you have your CV with all of your training, okay, and your years of experience. So they'll get the police officer on the stand. They may get you on the stand and they say, do you have a college degree? Well, maybe you don't. I don't really think the college degrees are what they were, 20 years ago. And I know what all of you have had to do to get to this position. And you have tons of training. Same with the police officers. So they're going to try to make you look, not so great. So they're going to say, do you have a college degree? No, but, and you can elaborate. This is the only time that I say elaborate. And you could say, but I have 15 years of experience. I've gone on 10,000 calls. I have this training and this training and this training. And then they just look like a complete idiot, because the jury's like, yeah, I don't have a college degree either, but that's great. Okay, so that's the time you can elaborate, but be ready for that question and be ready for them to try to make you look not so smart. All right. In deposition and interviews, understand, again, what you're preparing for. You're preparing for that trial. Criminal trials or civil trials, there's a different burden of proof. So prosecutors in criminal trials, they have the burden of proof, and their proof is beyond a reasonable doubt. Okay, you don't get too caught up in that, because again, just the facts, sir, that's what you're giving. Okay, in civil trials, it's a preponderance of the evidence, so any bit more than 50%. But again, you're not getting caught up in that, you're just giving the facts. One thing about the deposition and interviews, they could say, anybody seen My Cousin Vinny? Anybody seen that movie? Okay, so the two Utes, and they question the guys in the police department, and the police officer says, so you shot the clerk? And he goes, I shot the clerk? Question. Okay. He's like, he didn't even know what he was talking about. Okay. Now you get to the trial, and here's the prosecutor with the deposition or the interview, and he goes, you said you shot the clerk? And he goes, because he knew he was asking a question, but the prosecutor has now turned it into a statement. Okay. If they ever take anything that you've written in your report or anything in your deposition or interview, if they take it out of context, you will recognize that. So listen to their semantics, and they're really good at that. If they take it out of context, don't answer the question. Just say, can you repeat what I said before, or can you repeat what I said after? Because I need to have the full context. And there are evidentiary objections to that, and the prosecutor should say, that's taken out of context, and they'll make the record. And then they'll say, okay, what did you say before? Okay, so just be aware of that, because you didn't shoot the clerk, you were just asking, I shot the clerk, question, they're taking it as a statement. All right, secrets to get through it. Again, be leery of grandpa, the defense attorney talking to you about all his little grandkids, because he is really dangerous. Nice guy, but super dangerous in trial. Take deep, slow breaths, listen to all the questions. Again, clarify their questions before you answer it, because they will take it out of context when you get on the stand. Take your time, have your water. When you need to refer to your report, just ask. It's completely normal, like I said, completely normal. And if you don't know, just say, I don't know. I don't know the answer to that. I could, find it later for you. One question was yesterday, the defense attorney was asking the fireman how many times he had intubated, if I'm using the right word, intubated patients. And he's like, I have no idea. It could be thousands. And he said, but he was forcing me to give him an amount. And he's like, I can't give an amount. Is that okay? I'm like, that's completely okay. You can just say, calls during the week. Yes, we do that. This is what I do during my, when we do this procedure. How many times? I don't know. That's it. And he's got really upset. The defense attorney got upset, shut the interview down. Well, that's his problem. That's not yours. But don't elaborate if you don't know the answer. Remain cordial, because if you don't, they're going to get you on the stand and they're going to have a whole lot of fun with that, because that's what we like to do. We like to do that. I don't do that to the firemen or police officers. I do that with the IRS. So I know what I'm doing with them. Never fill in the blanks, never elaborate. Don't go down the rabbit holes. You set the speed. Whoop. Hold on. What is the last one? And remember that you're an honest person. Okay, any questions for me? Anything? Okay. I would definitely, yes. Uh-huh. I can answer that a couple ways. So let's just talk about less is more. If you write less is more for 1,400 calls and a year later you get called, are you going to remember anything about it? No. Mm-mm. So in that case, no, it is not. If you write more and you're writing facts, that they're facts, I would write it that way. Because again, what are you trying to prevent? A trial. The more you write, the more the defense attorney goes, what am I can't take this. It's all here. All he has to do is refresh his recollection and we got the whole thing going. So I would write more. Less in don't elaborate on stuff you don't know, more in what you actually observed in the facts. Okay? Yeah. Any other questions? Nope. Okay, I think I'm done. Yeah. I finished early.
Okay, come in and have a seat so we can get started. Back when I was in court, one of my big issues was that if I set a case to start a trial at 8 o'clock and everybody wasn't there, I started without them. And there were a couple of them where I'd call the trial and the public defender was out taking a pee. And before long, we were moving along before he even got in the room. They only do that once and then they show up, you know. Okay, we're going to hear now from Kim, and she was a prosecutor for 25 years, and I don't know where she is. Kim, are you out? Oh, there she is. You're supposed to be up here. By the way, if you happen to be on the apparatus that runs at my house when I have the heart attack, I really hope you're on time. I really do.
I got it. So, sorry I'm late. Oh, I don't have my papers. I don't know if you guys have my papers. Maybe I left him back there. I don't know. I don't. Can I use yours? I don't have any. Well, you need one of these. Yeah. Yeah. You're so sweet.
Thank you. I hold that a lot.
Actually, you know what? I'm just kidding. I did this to show what not to do. Don't come late. Bring your report, and do not ask anybody else in the courtroom if you can have their report, because it's their report. She was so very kind to give me her report, but if I take her report, guess who doesn't have a report? She doesn't have a report. I can't tell you how many times I've been, I'm a prosecutor, I've been waiting for my officer or my witness to come in. They've come in late, and then I'm frazzled waiting for them. They've come in late, they don't have their report, and then they're like, can I use yours? No, you can't use mine. This is my report. I need my report. So I did this to demonstrate. What did you guys all think when I walked in here late, got up here and was like, I don't have my report. Immediately, my credibility went down, didn't it? Don't do that. So let me begin again. My name is Kimberly Anderson. They announced it a million times. I'm a prosecutor. I've been a prosecutor for, 28 years, 27 years. I began at the city of Mesa, so this is like coming home for me. I spent about 5 years as a prosecutor with the city of Mesa. Then I went to Tempe for just shy of 3, and then finished up with the city of Chandler. Just retired from them after just shy of 20 years. Just recently was hired by the city of Mesa as a pro tem judge. Also got a contract with the city of Gilbert as a pro tem judge. Have not taken the bench with either one of them because that literally just happened. So super excited about that. Fun fact about me, I have a side business where I do interior decorating. Love that, that's my heart. Kristen is one of my absolute best friends, has been for a million years. I met her when her and I both were at the city of Mesa a gazillion years ago. So that's me, and I have 2 adult children. I tell everybody, little kids, little problems, big kids, big problems. If you have kids, you're gonna figure that out the hard way. All right, so my section on is in trial. So as a prosecutor, I had the opportunity to work with some of the most amazing officers, amazing firefighters that there, could be. But I did get to see a lot of some of the mistakes that witnesses can make, and some of the, best officers and firefighters testify. Not as many firefighters, obviously, as officers, just a few that I've witnessed over the years, really very few. But I do have a lot of experience with witnesses on the stand, and so I hope I can kind of impart some of that experience to you. All right, let's see. Punctuality. Again, what did you all think when I came in here late, scrambling, not knowing what I'm doing? Appearance. Like Kristen said, you earned your uniform, wear your uniform. You know, sometimes officers would come in a suit and tie, and, you know, y'all look great in a suit and tie or a very nice dress, but I always prefer your uniforms. Juries prefer your uniforms for sure. Posture. One of the reasons why I put this chair here was because as part of my little silly routine is I was going to do this because we see witnesses come in and they sit next to me if they're the case officer with this nonsense. I'm like, sit up. So that just goes to say, remember, juries see everything. They are watching everything that you do, absolutely everything that you do. And that also goes for me, the prosecutor, and for the defense attorney, and for everybody who's in the courtroom. They are watching everything that you do. One of the reasons is because sometimes they get bored and they're just, you know, paying attention to other things, but they are watching every single thing that you do. So dress appropriately, show up appropriately. They're paying attention to what you bring into the courtroom. Don't bring your phones, put your phones away. Just a little story, we had an officer, I'm gonna stand back up because that's rude, but we had an officer for the city of Mesa, Brad Withrow. I don't know if anybody knew Brad, but he was the Mothers Against Drunk Driving award winner for several years in a row, and he used to bring his notebook to trial, and it had those stickers on it, and the jury noticed that every time, and afterwards when I would talk to juries, I had a jury one time ask me about that, and so they paid attention to those things. So pay attention to what you bring with you when you come to a trial, how you dress, those types of things. Nonverbal signs, again. And you will be coming in blind, and what do I mean by that? Does anybody know what I mean when I say that the court will invoke the rule if you come to testify? Anybody know what that means? That's okay, you probably shouldn't know what that means. But when you come to testify, all the witnesses are put under what's called a rule. And that means that the judge gets all the witnesses together at the beginning of the trial and says, puts them all under oath, and then excludes all of them out into the hallway. And then the only person who gets to come in to the courtroom is just the person testifying and the case officer and the victims. So the case officer sits next to the prosecutor, and then outside of that, the only person who's in the courtroom who gets to watch, who gets to testify is just that person testifying. So one by one, the prosecutor goes out and gets the next witness, brings them in. And what that means is that the other witnesses aren't hearing each other testify. So if there's, 5 witnesses, 4 of them aren't hearing everybody else testify. The only person who's hearing everybody testify is the case officer. So odds are you aren't going to be a case officer. That's going to be pretty rare if you're going to be the case officer. So you aren't going to hear everybody else testify. And what that means is, or the purpose of that is everybody's not going to be aligning their testimony with everybody else. So you are only going to know what you know. So when you come in, you're just testifying to what you know, what you wrote down, what you remember. That's what we mean by you're going to be coming in blind. So it's very, very, very important that you review your report before you come in. And when I say review, I don't mean just kind of read it over after you get out of the shower that morning. I mean commit it to memory. You don't testify that often. In fact, I think Kristen asked how many people had testified before, and there was like 2 Raise your hand. How many people have testified? Just a handful? Yeah, so you don't testify that often. So when I say, if you're gonna testify, you need to commit that report to memory. You wanna limit the number of times that you have to say, I don't remember, because you need to remember. You will only rely on the facts as you know them. Judge Ferris just went over this, so I'm not gonna go over it again. Remember the model, the verbal, nonverbal language, eye contact with the trier of fact. So there's been tons and tons of studies on how juries work. You know, just the science of picking juries, the science of winning over juries, those types of things. And prosecutors and defense attorneys really get into that kind of stuff. And I'm one of those prosecutors who really likes that kind of stuff. And one of the things that I always tell witnesses when I have them on the stand, my professional witnesses, is that when you testify, by the time you're done testifying, you should have at least made eye contact with every single juror at some point. So when I ask you a question, pick one juror to answer that question to. When I ask you the next question, pick another juror to answer that question to. Don't answer the question to me or to anybody else. Answer the questions to the jury. So it should look something like this. You know, Officer so-and-so, at what time did you make the blood draw? It's not really a question for you, but those are the questions I'm used to answering. Officer, did you perform a blood draw on, you know, the defendant? Take a deep breath. Not an obvious deep breath, but take a breath. Turn, look at the jury and say, yes, I did. And then turn back. Officer, at what time did you perform the blood draw? Take a breath, turn, look at a different jury member, and answer that question. And so until you've answered all my questions and you've made eye contact with every single one. That does a couple things. First of all, like Judge Ferris talked about, you've made eye contact with every single one, and jurors don't look away when you're looking at them. And there's a whole science behind when people look you in the eye, they believe you. And second, one of the things I'm going to tell you, or a prosecutor is going to tell you when you come in, or a good prosecutor is going to tell you when you first come in, is help me monitor that jury. I've got a lot to do. You help me monitor that jury. And what prosecutors mean by that is help me pay attention to who is paying attention over there. Who's shaking their head doing this? Because what does that tell you? They don't believe you. You're losing that one. Or if the defense is talking, who's doing that? Who do we need to pay attention to? Who's got their head down? Who's nodding off? Help me do that. Help me pay attention to that, because then when you come off the stand and we go back into a break, tell me who those people are. Juror number 1 is shaking their head. That's good. Juror number 3 is going like this. I need to pay attention to juror number 3. So help your prosecutor do those types of things. And now, just as a side, I talk about a prosecutor in a room. That's because that's my background. But it's just as likely that it's going to be a plaintiff's attorney, like from your city attorney's office, because it's a civil suit. I have to remind myself to remember to explain that to you, because it's just as likely that it's not a criminal case, that it could be a civil case. And remember that you're painting a picture, like Kristen talked about. Paint the picture for them. Be very descriptive. Talk about colors. Talk about, the number of roads, the conditions, those types of things. Be very descriptive so that you can paint a picture for them. I could have said, be punctual. Remember to bring your report. Okay. But you're going to remember when I came in here pretending like I was late, asking everybody if they had the report. That's going to stick with you. If you are prepared, you will be relaxed. There's a saying amongst prosecutors, and probably amongst defense attorneys too, that if you prepare for a jury trial, odds are that jury trial won't go. The harder you prepare for a jury trial, the more likely it is to plead the morning of trial because you're prepared for it. If you don't prepare for it, that sucker's going to go to trial. So prepare and you will be relaxed. If you don't prepare, you are going to be a wreck when you get there because you don't know what you're doing. And that's not because of any other reason than this isn't your field. The person who said they would run into a building if there's, a small child and the building is on fire, which is every single one of you, that's because that's your field. This is not your field, so you gotta prepare. Be conversational. One of the ways that I like to do presentations like this and that I like to do trials is I like to do them conversational. And the reason why I like to do that way is because in settings like this and also in jury trials, people pay attention more and they absorb more when you just talk to them. So when I say conversational, what I mean is speak like your audience speaks. Read your room. Somebody, I think Judge Ferris asked what the layman's term was for a myocardial infarction. What's the layman's term for that? Heart attack. Little fun fact about me, not so fun. I had a heart attack when I was 48 years old. I had the heart attack actually in the cardiologist's office. They take me over to the hospital. They transport me over to the hospital. I don't realize what's going on though. I'm kind of a hairy-carry mess, but I don't realize what's going on. My daughter is in the hospital with me. My whole family's in the hospital with me, and she's freaking out crying. And I'm yelling at my husband. I'm kind of like a mess, but I'm yelling at my husband like, why is Bailey crying? Why is Bailey crying? And he says, because you're on the cardiac floor or something, whatever he's saying. And I'm like, no, I'm not. I'm in the ER. And he's like, you're not. You had a heart attack. And I'm like, I didn't have a heart attack. I had an MI. They said I had an MI. And he's like, you had a heart attack. And I'm like, no, I didn't. I had an MI. I had an MI. If you tell the jury that somebody had an MI, they probably won't understand what you're talking about. So say somebody had a heart attack. Use the language that your audience understands. If you say you got off the apparatus, I didn't know what an apparatus was till today. Say you got off the truck. Say you got off the fire truck. People love fire trucks. Say you got off the fire truck. Everybody lights up when they hear the word fire truck. So use the words that people understand. And admit when you don't know something. We've talked about this a lot. One thing that you will understand, or one thing that you will pick up on here, is that we repeat the same things over and over again. And truthfully, that's the lawyer in us. We've all been trained in this, theory that if you repeat things over and over again, people get them. I don't know if that's really true or not. But as lawyers, we've been trained to do that. And so we will repeat things that we know are the cornerstone of this subject. And one of the cornerstones of this subject is admit when you don't know you're wrong. Don't fill in blanks and don't think to yourself, I do this the same way every single time, so I must have done it that way on this time. But I don't have an independent memory of it. But I know I must have done it this way on this time. So I'm just going to say that I did it, but I don't remember specifically. Odds are you probably did do it that way on that time. But what if it's that one time when you didn't do it that way and you say you did it that way, but somehow in the report that you didn't memorize, you didn't do it, and the defense attorney has that report and you didn't do it that way, and he knows you didn't do it that way, and your credibility is about to go down the tank. It's just as easy to go, I don't have an independent memory, I don't remember. Give short, precise answers. There are some exceptions, but the vast majority of the time, just answer the question that is in front of you. Your prosecutor or the state's attorney in a civil case will know that they need to follow up. Don't worry about that. They will know when to come back and flesh out the answer more. Don't worry about that. Just answer the question that's in front of you. Again, paint the picture. A lot of people say that, including myself, say that trials, whether they're civil or criminal, are puzzles, and that each witness or each piece of evidence is like a small piece of the puzzle. And for the vast majority of times, that is true. But I want you to think about something. There are times when there is one tiny piece of the puzzle that can ruin the whole puzzle. Do not be that one tiny piece of the puzzle who was going to fill in a blank with something that ruined the whole puzzle. Here's what I mean. Everybody know who that is? Now, yesterday I discovered that there were people in the room who were too young to know who that was. Anybody too young to know who that is? Does everybody know who this is? All right, all right. So don't be that piece of the puzzle. He is living proof that one witness can be the one bad piece of the puzzle. What is cross-examination? Cross-examination is a constitutional right of the defendant to confront his accuser. So if you're on the stand, you're going, if you're subpoenaed and that trial goes, you're going to get cross-examined. The defense attorney's job, or the in a civil case, the other side's attorney is going to cross-examine you. And it's their job to impugn your credibility, to get out bad facts, those types of things. You wouldn't be there if that's what, if they weren't going to do that. So you got to prepare yourself for that. One of the ways to prepare yourself for that is to prepare before you get there. Know your report. That's the first thing. And the second thing is, don't fight with them. Do not fight with them. Because let me tell you, you know who's going to win? They are. It doesn't matter how good they are. It doesn't matter how new they are. It doesn't matter how old they are. They will win if they get you to fight with them. That's the golden rule. If they get you to fight with them, if they get you flustered, if they get you riled up in any way, shape, or form, you have lost. I have never in all my years seen a witness get flustered and upset and win that battle. Now, I may ultimately win the case, but I've never seen the witness win that battle. So don't do it. Remember to stay calm and just answer their questions. Remember, trial attorneys want you to think they know it all, including prosecutors. But here's the thing. The only person in the room who knows it all is the witness. Nobody beyond that witness box knows anything because we weren't there. You guys were there. The witnesses were there. The judge wasn't there. The prosecutor wasn't there. The state's attorney wasn't there. The plaintiff's attorney wasn't there. The defense attorney wasn't there. We weren't there. You guys were there. You are the ones who need to paint the picture. There is a strategy amongst attorneys, both prosecutors and defense attorneys, when an opposing witness is on the stand that goes something like this. Rile them up by making them go so fast that they can't think about their answer. And that's just rapid fire ask questions. Make them go really fast. And attorneys are really good at that. We do it in the courtroom, and incidentally, we do it to our kids. So one of the ways that you can take control of that is you control the pace. And a lot of times witnesses think they can't do it, but you can do it very easily. And how you do it is when the question comes in, you just refuse to play ball. Just make them slow down. When the question comes in, just pause. Take a drink of water, smile, look at the jury, and think for a moment, answer your question, maybe say, sir, madam, could you repeat the question? Make them slow down. That rapid fire question, that isn't an attorney's personality, that isn't just happenstance, that is a strategy that they are using. So you make them slow down. They will get very frustrated by it. But you can control the pace in the questioning. Refuse to play ball with them. Just make them slow down and consistently do it. Even if it's something like an easy question, like just a simple kind of softball question. Take a breath, appear to think for a second, take a drink of water, and then answer. Force them to slow down. And again, if opposing counsel riles you up, he wins. If you get a subpoena, your first instinct for a lot of people, including police officers, is kind of like, oh crap. I know, I learned this yesterday, but I know that you guys have a procedure for when you get subpoenas. They go to, where do they go? What? Okay, so they go to Sherry, in Mesa they go to Sherry. And you know, actually let me ask, is there other agencies besides Mesa here? Where are you from? Gilbert? Yeah, Gilbert. Any place else? Fountain Hills? Ooh, that's a long ways. Where else? Anybody else? Just those two? All right. So when you get a subpoena, whatever your procedure is, obviously follow that. But I'm sure your first inclination is, oh, crap, like why'd I get a subpoena? What is the issue? What's going on? But I will tell you, if it comes to fruition that you have to testify, you can always contact the state's attorney, the prosecuting attorney, whoever the entity is, and ask, can I come down and just watch a trial? Can we talk about like what the issue is? Like what's going on? Ask Sherry, ask whoever, like, what is the issue? You don't have to go into any of these things blind. Ask the state's attorney, the prosecuting attorney, whoever it is, can I come down and watch? Can we have, like a little quick meeting? Can we talk on the phone? Can we figure out like what the issue is? What are they going to ask me? Those types of things. You've probably already had maybe a deposition or an interview about it, but you don't have to go into any of these things blind. And even before you get a subpoena, if this seminar prompts you to go, hey, maybe I want to go down and watch a trial, just contact your city attorney's office or your city prosecutor's office. And what days do you do trials? And pop in and watch one so that you have like some context for it. They're not, then they won't be nearly as scary when you go in. Also, one of your best resources is any of your other firefighters who have actually testified. Ask them about what happened, how it was, what kind of questions they got. Ask any of the police officers in your department or, in your city, what it was like for them. Or ask any other agency firefighters what it was like. There are resources out there that you can tap into, but you don't have to go into any of these situations blind. Obviously, if you do testify, one of the first things that you want to do is talk to the state's attorney, plaintiff's attorney, whoever it may be, and get some feedback. How did I do? Do you have any tips for me the next time I do it? In summary, honesty, honesty, honesty. And one thing that I want to point out is we harp a lot on honesty, don't lie. And lie is a harsh word. I want to make sure that nobody up on this stage thinks that anybody over here is lying, would lie, anything like that. What we're actually talking about is trying to fill in gaps with what you always have done, so you believe that's what you did on maybe this call. No one ever thinks that anybody back here in one of these uniforms is going to lie on the stand. That's not what we're talking about. Integrity, you earn the right to be here, so don't ever do anything in the courtroom that could make a jury perceive you in any other light. Understand your role in the system, understand the importance of visual impressions, know the laws that applies to you, master your language skills, body language, paint the picture, temper. Any questions?